About Law. My name's Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about when it makes sense to file a Chapter 13 bankruptcy versus a Chapter 7 bankruptcy. So let's start by talking about the differences between a Chapter 7 bankruptcy and a Chapter 13. A Chapter 7 bankruptcy is much more common because for most people that are on the brink of bankruptcy, it makes the most sense. And that's because all of your debts in a Chapter 7 bankruptcy are immediately discharged, assuming that they're dischargeable debts. Certain types of debts are not dischargeable. We have a lot of articles and videos about Chapter 7 bankruptcy at learn-about-law.com, so I won't go into too much detail about it here. You can learn more there at our website. But the bottom line is, in a Chapter 7 bankruptcy, the trustee takes a look at all the assets you have, and if you have certain amounts of assets over and above the exemption amounts, so $15,000 in your home is exempt from collection by the trustee, $2,400 of equity in your vehicles, you've got a $4,000 wild card exemption that you can apply to anything. If you have assets over and above those amounts of collectible property, then the trustee can collect that property and use it to pay your creditors. For most people, they don't have assets over and above the exemption amounts if they're thinking about a bankruptcy. So we don't really worry about that. Chapter 7 makes the most sense because all of your debts are immediately wiped out. And most of the assets that you have fall within the exemption. So we usually recommend a Chapter 7 for those types of people. In a Chapter 13 bankruptcy, rather than your assets being used to pay your debt, your future income over the next 3 to 5 years is used to pay your debts. So unlike a Chapter 7, the trustee doesn't liquidate your assets and pay the debt. The trustee approves a payment plan for the course of 3 to 5 years so that some or all of your debt can be paid off through that payment plan. And in a Chapter 13 bankruptcy, if your income over the next several years is not going to be enough to pay all of your debts, in some cases, you can receive a discharge without paying the full amount of the debt. But like I said, unless there's certain specific situations which we'll discuss, Chapter 7 tends to be, as a default, the more beneficial to most people. Now, let's talk about who can benefit from a Chapter 13 as opposed to a Chapter 7. The first and most obvious is people who are not eligible for a Chapter 7 bankruptcy might want to file a Chapter 13. If you've had your debts discharged through a Chapter 7 in the past 8 years, you're no longer eligible for a Chapter 7, but you may be eligible for a Chapter 13. If your income is too high for a Chapter 7, then you may be eligible for a Chapter 13. So in a Chapter 7 bankruptcy, you have to go through something called a means test. And while most people don't have too high of an income to file a Chapter 7, some people do. And if you're over and above the bar for this means test, you're ineligible for a Chapter 7, but you might be eligible for a Chapter 13. The second reason that people most likely might file a Chapter 13 rather than a Chapter 7 is because they have a lot of equity in their home or vehicles and want to keep those assets. So or other assets that might be collectible through a Chapter 7. So, like I said earlier, debtors in bankruptcy have certain amounts of exemptions in each class of assets. So, in your home, an individual debtor gets to keep $15,000 of equity in the home. Like I said, in the car, it's $2,400 in your vehicles, and then there's this $4,000 wild card exemption that you can apply to any property. So if you have, let's say, $60,000 of equity in your home, but you have a whole bunch of debt and getting a home equity loan to pay off the debt isn't a good idea, you may still want to keep your home. You may want to keep your vehicle. You may have other assets you want to keep, and you prefer to just pay off you want to stop collection efforts, so you want to pay off the debt over the course of 3 to 5 years. Now, the good thing about a Chapter 13 bankruptcy, like a Chapter 7, there's something called an automatic stay of collection efforts from the time you file and through the duration of the bankruptcy, and that's the whole duration of the payment plan. So for people with assets that they want to keep, but they want to stop a collection effort from happening, they can file a Chapter 13, come up with a payment plan, and during the course of that payment plan, creditors have to stop any collection efforts, and at the conclusion of the payment plan, the remaining debt is discharged. So a big reason that people do a Chapter 13 is because they have too many assets to do a Chapter 7, and if they did a Chapter 7, they'd be at risk of losing a lot of those assets. A similar reason to do a Chapter 13 bankruptcy rather than a Chapter 7 is because you are behind on your mortgage payments or car loan payments. And even though you may not have too much equity in those assets to qualify for the exemption or to have the exemption protect the property in the bankruptcy, the fact that you're behind on the loan will put those properties in jeopardy in the Chapter 7 bankruptcy. So let's talk about how that works. So in a Chapter 7 bankruptcy, if you are current on your payments and you have equity within the exemption amount, so if you've got $15,000 or less of equity in your home and you're current on your home payments, you can talk to the bank or whoever has the loan and work out a reaffirmation agreement. And what that is saying, well, we're going to wipe out all of our debts in the bankruptcy, but we're going to basically keep the loan and not wipe out the loan and continue. We're going to reaffirm the loan and continue to pay on the loan. And that allows people to keep their home and cars in bankruptcy. And again, we have an article and video about how this works on our website, learn-about-law.com. But so in a Chapter 7, if you can sign this reaffirmation agreement, you're likely to be able to keep your home and vehicles. But a lot of banks won't sign reaffirmation agreements if you have an arrearage. And an arrearage is an outstanding amount that's past due past due payments on your loan. So if you're behind on your mortgage by a couple months, you can't you may not be able to sign a reaffirmation agreement in a Chapter 7 bankruptcy. So filing a Chapter 7 will put your home or vehicles in jeopardy because you've got these past due payments and you won't be able to do a reaffirmation agreement. Now, sometimes you can, so I don't want to make you think you can never work out an arrearage in Chapter 7. But in a Chapter 13 bankruptcy, you can basically pay off the arrearage, the amount that's past due, through the Chapter 13 payment plan and continue to pay future payments outside of the payment plan directly to the lender. So it allows people who want to keep their home and are behind on payments to come up with a payment plan to pay off the past due debt and keep their home where they may not be able to keep their home in a Chapter 7. The next reason that people might want to do a Chapter 13 instead of a Chapter 7 is because it protects co-signers and guarantors on loans in ways that a Chapter 7 doesn't. So in a Chapter 7 bankruptcy, you wipe out all your debt in your obligation to the creditor, but anyone else who signed for you, co-signed or guaranteed the loan, the creditor can immediately pursue them. The Chapter 7 automatic stay doesn't prevent the creditor from going after anyone who co-signed or guaranteed the loan. So a lot of people who are filing for bankruptcy don't want to basically screw over the people that helped them get this loan. So a Chapter 13 bankruptcy will put an automatic stay as to collection not only on the bankruptcy filer, but also on all of the co-signers and guarantors of the loan. So this gives them protection for the 3 to 5 years over the course of the bankruptcy that they won't be pursued for the loan. Now, if you don't end up paying off the entire amount of the debt through the payment plan of the bankruptcy and the rest of the debt is discharged, then the creditors at the conclusion of the bankruptcy can still go after co-signers and guarantors for any amounts that ended up being unpaid in the bankruptcy. But it's still a higher level of protection than a Chapter 7 where your debt is wiped out, but anyone who signed or guaranteed the loan for you is immediately pursued by the creditor, and you're putting them in a real tough position. Another thing you should know is that Chapter 7 cases can be converted into Chapter 13s if the facts or the situation on the ground changes. So if we think, hey, maybe you're a good candidate for Chapter 7, and we learn things later on throughout the course of the case that, or the trustee makes decisions we don't anticipate where your property is going to be in jeopardy, we can convert the Chapter 7 to a Chapter 13 midstream. And that's a pretty common thing to do. So let's talk about the Chapter 13 eligibility requirements. You can't file a Chapter 13 bankruptcy if you have more than $394,725 in unsecured debt or more than $1,184,200 of secured debt. Secured debt is debt that is supported by collateral, and collateral is property that whoever gave you the loan can come back and take, like your home or your cars, if you default on the debt. So a mortgage or a car loan is typically a secured obligation because the person who gave you the loan can come back and foreclose on your home if you don't pay the debt. Unsecured debts are debts that aren't supported by collateral. So there's no property for those creditors to come and take. So if you have less than those amounts, about $400,000 in unsecured debt and a little bit over $1 million in secured debt, then you are likely eligible for a Chapter 13 bankruptcy. The second test for eligibility is based on previous bankruptcy action. So if you had a previous bankruptcy case that was dismissed based on your willful failure to appear in court or comply with court orders, then you're going to be ineligible for bankruptcy for 180 days after the dismissal. Similarly, if you voluntarily dismiss the case after a creditor requested relief from the automatic stay, so they asked for permission to collect from you, and you voluntarily dismiss the case, then again, it's going to be a 180-day waiting period before you can file again. So in summary, for a lot of people, Chapter 7 makes the most sense because your debts are wiped out. But for people with high amounts of assets or arrearages in their mortgage and they're trying to keep their home, or who are not eligible for Chapter 7, or who are trying to protect their co-signers or guarantors, Chapter 13 can be a good option that's preferable to Chapter 7 and meets their needs in a better way. So part of what we do as attorneys is kind of assess the facts and the goals of the person filing for bankruptcy and figure out whether, first of all, whether bankruptcy is the best option at all, and if it is, whether Chapter 7 or Chapter 13 makes sense. Thank you so much for listening.
Thanks for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit makingrealestatefun.com for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.